Way, is the Executive Director for Freedom for Faith. Our Associate Dean, Dr. Keith Thompson, is strategically positioned at the back of the room, and other members of the School of Law staff, distinguished guests, which includes every one of you. Welcome to the University of Notre Dame School of Law. Those of you who don't know me, I'm Professor Michael Quinlan, as it says up there. I'm the Dean of the School of Law here in Sydney. And welcome to the 8th Annual Religious Liberty Lecture, which is going to be presented this evening by Monica Doumit. The University of Notre Dame, Australia acknowledges the traditional owners of the land on which the Sydney campus is located, the Gadigal people of the Aurora Nation, and pays respect to elders past and present and emerging, for they hold the knowledge, traditions and culture of their people and their land. At every religious liberty lecture and conference so far that I've spoken at, I've always chosen a short passage from Scripture, which hopefully helps everyone to focus on the conference theme. So this year's conference theme is religious freedom and inclusivity, compatibility, conflict and the future. So tonight and tomorrow I'd like to invite you to ponder this text from the second letter to Timothy, chapter 4, verses 1 to 2, and I'm using the New Jerusalem Bible translation. So it reads, proclaim the message and welcome or unwelcome, insist on it. Refute falsehood, correct error, give encouragement, but do all with patience and with care to instruct. Proclaim the message, and welcome or unwelcome, insist on it. Refute falsehood, correct error, give encouragement, but do it all with patience and with care to instruct. So how does that requirement, how does that instruction fit with the contemporary understanding of inclusion? Notre Dame School of Law in Sydney has had a strong focus on religious liberty since its inception. And this fact is evident from its publication, the first publication in our new publishing imprint, the Shepherd Street Press, which is called Religious Freedom in Australia, a New Terra Nullius. I'm told, but I'm not sure now, that copies should be available for purchase today. Dr. Keith Thompson will be able to resolve that question for you if you would like to buy a copy tonight. Because what a great Christmas present. What a great Christmas present that would be. Whilst I'm making announcements, I also mention that Greg Bondar has brought along some copies of the annual report of Family Voice, and they're available for collection if you're interested at the table at the back. Now, as we wait to see what amendments will be made to the Commonwealth Government's exposure draft of its religious discrimination bill, and whether it will pass, and we wait to see whether the state law that the Honourable Mark Latham has prepared for consideration in New South Wales, and whether that will progress in this state, religious freedom has never been more important. Add to those developments the increasing number of states and territories in Australia which have passed laws mandating the referral of patients seeking an abortion by health professionals who have a conscientious objection to that practice, and the increasing number of states and territories which have criminalised a wide range of activities including public prayer and the offering of support and information about alternatives within designated exclusion zones near facilities where terminations of pregnancies take place, and the increasing number of states and territories in Australia which have acted to abrogate the seal of the confessional. And you get the very strong impression that things in religious freedom land are far from fine. It's worth pondering the fact that even in California, that most liberal of states, the Parliament recently rejected legislation which would have overridden religious confession privilege in a much, much more narrower scope than has happened already in many states and territories of this country. As the Dean of a Catholic law school in a Catholic university, the University of Notre Dame, Australia, religious freedom is more than just a concern or an area of interest. I simply could not do what I do every day, and nor could the staff in the school do what they do every day without religious freedom. So it really is an existential question, an existential issue for the School of Law and for this university, and for every faith-based institution. The School of Law Sydney Annual Religious Liberty Lecture was established way back in 2012. In more recent years, we've had to add a full-day conference a day after the lecture because the issues have grown exponentially and they continue to do so. And I would encourage everyone here to attend our 3rd annual conference on religious liberty, which will be taking place in this very spot from 9 o'clock tomorrow morning. And if you haven't collected one, programs are available at the back of the room. If you do take a program, that means you have to come tomorrow. If not, please leave it behind when you leave. We have speakers joining us for the conference. Some of them are here tonight from overseas and interstate, so I do hope you can join us. And if you've had a look at the program, you'll see it's an excellent program tomorrow. But tonight's the night for our annual Religious Liberty Lecture. Since 2012, our speakers have included Brigadier Jim Wallace, Cardinal George Bell, the Honourable George Brandis when he was Commonwealth Attorney General, and Elder Quinlan Cook of the Quorum of the 12 Apostles of the Church of Jesus Christ of Latter-day Saints. Over the last 3 years, the lecture has been delivered by 3 leading law and religion academics: Professor Ian Benson, Professor Rex Adar, and Professor Dan Peterson. But tonight our lecture will be given by Monica Doumit, and I'm so very pleased that Monica agreed to give this talk tonight, although she did so quite a long time ago, so she may be regretting that decision. Like many of you, I'm sure I read the page in the Catholic Weekly she writes each week religiously, and I almost always agree with what she has to say there entirely. This only confirms, I'm sure you'll agree, the quality of Monica's thinking and the quality of her writing. She really needs no introduction, but suffice to say that Monica is a writer and public speaker on issues of faith and its intersection with public life. Since October 2018, she's been the Director of Public Affairs and Engagement for the Catholic Archdiocese of Sydney. From August 2017 to January 2018, Monica was the Director of Communications for the Coalition for Marriage. Prior to entering the world of communications, Monica was a senior lawyer in the financial services sector. She holds degrees in medical science and law and a Masters of Bioethics. She really is a fantastic person, and she's here with us now to talk on the topic mandatory inclusivity and practical marginalisation, 2 sides of the same coin. Let's welcome her now.
What a very generous invitation. Thank you, Michael, and thank you all for being here this evening. When Michael invited me to deliver the annual Religious Liberty Lecture back in March, there were many things that had not yet happened. The coalition government had not been returned at the federal election, and so we didn't have the prospect of a religious discrimination bill on the horizon. We didn't know that Labor would attribute its election defeat, at least in part, to losing the Christian vote. And even if we had predicted the election outcome, we definitely did not know that we would be expecting the religious discrimination bill to be tabled in this sitting fortnight. The New South Wales abortion bill had not been announced, let alone passed, and people of faith had not filled the streets standing for life and showing that they were willing to make their voices heard. Mark Latham had not yet been confirmed as a member of the New South Wales Legislative Council, and so his state-based religious discrimination bill was not even on the horizon. The Council of Attorneys General had not decided to commission a working group into the abolishing of protections for the seal of confession, and we weren't expecting an announcement about its findings tomorrow, nor were we expecting the West Australian Government to today table a bill abolishing the seal. The Victorian Government had not commenced its inquiry into conversion therapy, nor the ACT announced its intended ban of the same. And Israel Folau hadn't posted about unrepentant sinners on Instagram. If I knew all of those things were going to transpire in the intervening months, then I might have suggested to Michael that I would be washing my hair this evening. But here we are. And obviously it would be impossible to address each of these issues tonight, let alone the legal, social and political circumstances that have brought us to this point. So this evening what I'd like to do is to focus on those issues that will most immediately feature in parliamentary and public debate in the next 12 months or so. Laws that touch on the intersection of different rights and freedoms are unavoidably complex, and we will need the great minds in this room and many more to ensure that we get them right. And so to encourage this, it's my intention to offer a little bit more detail on the potential long-term consequences of the short-term political landscape so that we might all best direct our efforts. Specifically, I would like to consider the Federal Religious Discrimination Bill and the related inquiry by the Australian Law Reform Commission into the removal of exemptions from federal anti-discrimination acts, the proposed bans on conversion therapy, and attempts to remove protections for the confessional seal. I think that's probably enough to keep us busy. So the title of this paper is Mandatory Inclusivity and Practical Marginalisation, two sides of the same coin, because it seems to me that the push for inclusion is having the effect of outlawing the public expression of religious belief, particularly Christian belief, in works, in words and in worship. And despite tonight being the beginning of the University of Notre Dame's Religious Liberty Conference, mine is actually not the opening talk on religious freedom and inclusivity. Last week at the National Press Club, Federal Attorney General Christian Porter graciously opened proceedings by giving his own talk on the topic. The Attorney General recognised that limits on inclusivity are important to protect religious freedoms. He said that when we seek to protect people from being excluded because of their religion, we equally recognise that for religion to exist at all, religious bodies must be able to maintain a chosen level of exclusivity to their premises or composition or services. For instance, the Attorney General said, a religious school may admit students of many faiths, or it may prefer students only of its own faith, but that discretion is not viewed by other faiths as discriminatory because they understand and accept its existential importance to all faiths. What he was saying was that the ability to exclude is necessary for the existence of more than one faith, that in order to be inclusive of all religious beliefs, in order to enable a truly pluralistic society, the law must allow religious groups to exclude some people and beliefs and practices. The Attorney General's point was well made. An element of exclusivity is fundamental to the protection of religious belief and of religious freedom, and it's not discriminatory to assert that. And while I think this is a perfectly reasonable position, it's a hard sell because in the court of public opinion, inclusivity is really the virtue of our time. In many cases, it seems that inclusion of all is a prerequisite to the right to exercise any other freedom, including the freedoms of association, of religion, and of worship. Worst thing when you're using an iPad to see. Taken to its legal and logical conclusion, mandatory inclusivity results in uniformity. In a society where no one is truly free and where the only ones excluded are those who want to express some point of difference. We have become so inclusive in our society that the justification for tearing up Israel Folau's rugby contract, for paraphrasing St Paul's letter to the Corinthians, was that he breached Rugby Australia's inclusivity policy. So inclusive that the proposed bans on conversion therapy will endorse all types of sexual activity and attraction, except for chastity. And so inclusive that a major Australian company has recently changed its Christmas celebration to an end-of-year celebration, even though the same company this year observed Ramadan and Pride Week, obviously not at the same time. In a bid to include everyone, all faiths and none, all sexualities and ideas, we have brought ourselves to the practical marginalisation of religious belief, especially Christianity. Proposed laws, even those touted as protecting religious freedom, will almost certainly cement this practical marginalisation. Let's look more closely at some of those laws now. I'd like to turn first to the Religious Discrimination Bill, the exposure draft of which was released by the Attorney General just on 3 months ago, and the next iteration due to be tabled in Parliament any day. The bill is mainly in the form of other federal anti-discrimination laws, such as the Racial Discrimination Act, the Sex Discrimination Act, and the Disability Discrimination Act. It prohibits the direct or indirect discrimination of a person against a person on the basis of religious belief or activity or lack thereof in areas such as employment, accreditation, education, access to premises, provision of goods and services, facilities and accommodation. It provides a number of exemptions where the prohibitions do not apply. For example, while it's generally prohibited to discriminate in employment on the basis of religious belief, the bill includes an exemption for bodies established for religious purposes so that they can hire people who share their faith. If passed, the bill will close a significant gap in New South Wales and South Australia in particular, because religious belief is not a protected attribute in the anti-discrimination laws for these states. In that respect, the bill is a welcome start, in that it recognises the need to address the growing concern among people of faith that they are not free to express their religious beliefs in public without consequences for employment or under anti-discrimination law. Importantly, the bill seeks to address the Archbishop Julian Porteous matter by making it clear that statements of belief do not constitute discrimination, and specifically overrides state-based anti-discrimination laws that would suggest otherwise. This provision is being heavily opposed by some who see it as an imposition on states' rights. However, without a cover-the-field approach, the federal law would be incapable of providing any protections for speech. This section isn't perfect. The protections are expressed to not apply to statements of belief that harass or vilify, which the explanatory note accompanying the draft said included religious expression where it may cause harm to a person or group of persons or the community at large. Interpreted widely, the harm principle has the potential to make the protections for statements of belief meaningless. All Martine Delaney, the trans woman who brought the case against Archbishop Julian, would have had to do was to argue that the pastoral letter vilified her and others in the LGBT community rather than offended, humiliated or insulted them to continue with the claim. But the provision's a start. The bill also seeks to dispense with the Israel Folau matter by declaring it unreasonable for employers with an annual turnover of $50 million or more to restrict the expression of religious belief outside of employment, unless the restriction is necessary to avoid unjustifiable financial hardship to the employer. But this section isn't perfect either. It suggests that religious freedom rights are variable based on where you work, and it could encourage boycotts, sponsorship or advertising withdrawals in order to enliven the unjustifiable financial hardship exception. It also leads to an interpretation that small or medium-sized companies are therefore permitted to place restrictions on the expression of religious belief outside of work, and as well as the expression of religious belief inside the workplace. But again, it's a start. It acknowledges the Folau case as something that we don't want to occur and does make an attempt to resolve it. Another positive aspect is that the ability of religious bodies to conduct their affairs in accordance with their doctrines, tenets and beliefs is not characterised as an exemption, but rather as an activity which in and of itself does not constitute discrimination. The recent announcement last week that religious bodies will include hospitals and aged care facilities means that the protections will be broad. It doesn't yet cover other activities that could be deemed to be commercial, but are central to our mission, things like retreat centres or even our beloved Vinnie stores. But again, it's a start. It recognises that the manifestation of religious belief includes how we operate our hospitals and our aged care facilities. The next iteration, as I mentioned, of the bill is to be released shortly, and so we'll need to wait to see if any of these concerns have been taken into account. But even if the bill does turn out to solve the religious discrimination problem, it's not going to fix religious freedom, because the religious discrimination bill only deals with discrimination on the grounds of religious belief or activity, and not on any other protected ground such as marital status, sexual orientation or gender identity. Whatever the outcome of this bill, the freedom of religious schools, educational institutions like this one, and other bodies established for religious purposes will be put to the test with the Australian Law Reform Commission inquiry, tasked with looking at the removal of religious exemptions to anti-discrimination laws, including the Sex Discrimination Act. And there's a real risk, it seems to me, that the passage of the Religious Discrimination Bill might be used as a trade-off for the removal of these exemptions, which are much more critical to us in our ability to run our schools and other organisations in accordance with Catholic teaching than any religious discrimination bill. Let's just consider the Sex Discrimination Act for the moment and the proposal to remove or to severely limit the exemptions in that act to allow religious schools to discriminate against students on the basis of sexual orientation or gender identity. Even though the Radical Review recommended this exemption be retained, it's very difficult to argue in its favour. Our opponents argue that it allows Catholic and other religious schools to expel gay students or to subject them to other types of degrading treatment. In response to these narratives, our schools and our bishops are at pains to tell people that we don't discriminate against LGBT kids, we don't want to, and then therefore leads to the implication that these exemptions are not necessary for the proper operation of religious schools. But here's the problem. Giving away these exemptions in return for a Religious Discrimination Act, or to avoid being seen as discriminatory, will affect the way we run our schools and the rights of parents who choose to send their children to religious schools. Section 21 of the Sex Discrimination Act provides, among other things, that it is unlawful for an educational authority to discriminate against a person on the grounds of the person's sexual orientation or gender identity by denying the student access or limiting the student's access to any benefit provided by the educational authority or by subjecting the student to any other detriment. Section 38(3) then provides an exemption for educational training conducted in accordance with the doctrines, tenets, beliefs or teachings of a particular religion or creed, if done in good faith and in order to avoid injury to the religious susceptibilities of adherents to that religion. It's an exemption that we're all quite familiar with, I think. The removal of this exemption would have far-reaching implications. Let's go back for a moment to Section 21 and take a look at it in respect of the provision of sex education for a moment. Schools are not permitted to limit a student's access to any benefit or subject them to a detriment on the basis of sexual orientation. It is at least arguable that sex education is a benefit provided to students, or alternatively, that the failure to provide them with sex education is a detriment. A case could be made by a student who identifies as gay that by failing to teach same-sex sexual activity, they are being denied a benefit offered to other students, the benefit being sex education that is relevant to them. And it's not a stretch. In speaking about the rights of parents to remove children from sex education classes, the Ruddock Review said that this needed to be balanced against the right of the child to receive information about sexual health. Without the Section 38(3) exemption, all religious schools could be required to offer a broad range of sex education to students, and with no regard to the rights of parents who choose to send their children to religious schools because they want them educated in accordance with their beliefs, including and especially when it comes to sex and sexuality. Or, in another example, suppose a student wishes to bring the same-sex partner to the school formal. A number of religious schools do allow this, but a removal of the Section 38(3) exemption would mean that no school would ever be allowed to limit formals to couples of the opposite sex. Or let's consider a school student who's experiencing gender dysphoria and who informs the school that they would like to transition, wearing the uniform of their chosen sex, participating in sporting teams of their chosen sex, and using the bathroom and change room facilities of their chosen sex. With the Section 38(3) exemption removed, a school would not be able to resist these requests, because undoubtedly forcing a student to wear the uniform or use the facilities something other than their chosen gender would be seen as subjecting them to a detriment. The student could also insist that they be addressed by both teachers and students with their preferred name and pronoun, and a school would have to enforce this to avoid opening itself up to an anti-discrimination suit. This is the exact same question that launched Jordan Peterson into the spotlight. So to flesh this out just a little bit more, I'd like to enlist the assistance of a hypothetical Catholic family. Meet Maggie. She's your eldest. She's bright as they come, and she's in Year 8 at an independent Catholic girls' school somewhere in Sydney. Her little brothers, John and Tommy, are in Year 5 and in Year 3 respectively at your local Catholic primary school. Let's start with John. John's coming to the end of primary school, and so we have the personal development curriculum that deals with puberty, sex ed and everything else. You can't believe you're already talking to John about sex, but you went through it with Maggie a few years ago and you think you're kind of well prepared. But the sex ed curriculum has changed considerably since that time. Anti-discrimination laws mean that school sex ed now has to treat all types of sexual activity as equal. John not only learns about the birds and the bees, but the birds and the birds and the bees and the bees and the different types of assisted reproduction that can help them to have babies. The school is no longer allowed to teach that the Catholic Church opposes IVF and surrogacy because it's seen as discrimination against rainbow families. He learns that trans men can be pregnant too, so it's better to talk about pregnant people rather than pregnant women. You're a little worried that John is still too young to be exposed to all of this detail, so you ask if maybe he can sit out the classes dealing with anything other than traditional male and female sexual activity. Unfortunately, the school tells you, a recent Victorian Supreme Court case has said that allowing parents to exclude their kids from the LGBTI sex ed stuff is a form of bullying and discrimination, and so they can't allow it to happen. The principal understands your point and feels really bad about it, but her hands are tied. What about Tommy? Well, Tommy has had a good friend since kindergarten named James. They've been friends all these years, and you've always known that James has been a little different from the other boys in his class. When Tommy and James have a play date, James is always more interested in your clothes and discussing your hair than he is about kicking the soccer ball around in the backyard. Tommy comes home from school one day and tells you that his teacher told him that James is really a girl and that his name was Jenny. Her name is Jenny. Tommy quickly corrects himself. Jenny's come back to school after a few weeks off, and her hair is a little longer. She wears the girls' uniform and uses girls' toilets and everything. Can boys really be girls, Mum? He asks. No, darling, you say. James is still your friend and you still have to be kind to him and play with him and invite him over, but he's still a boy. He's just going through a bit of a phase right now. Do you remember when you dressed up as a lion for book week? You looked like a lion and you could roar pretty loud, but you were still Tommy. It's just the same as that. Tommy seems satisfied with the answer and you're pretty pleased with yourself that you've gotten out of such an awkward conversation with a little bit of grace and without too many questions, and you get back to making dinner. A couple of weeks later, you get an email from Tommy's teacher asking you to come in for a meeting about Tommy's behaviour. Tommy's a good kid and you can't really understand what's going wrong, but Mrs. Smith tells you that Tommy has repeated to Jenny what you said, that he's just going through a phase and that he's really a boy named James and he's just playing dress up. Jenny's parents have complained to the school, and so they're going to have to start punishing Tommy if he keeps it up. You get a little angry, as you would, and say, well, you didn't even warn the parents that this was happening. I had to deal with it on the spot when Tommy came home. Wouldn't it have been better for James to start at a new school as Jenny, so parents wouldn't have to have these conversations? Mrs. Smith explained that because of the removal of exemptions that were contained in the Sex Discrimination Act, the school wasn't allowed to present this as an option because that was discriminatory. It would be better, Mrs. Smith advises you, if you would just explain to Tommy that Jenny is a real girl and he needs to treat her like that. But it's not true, you protest. And Tommy's pretty easily influenced by his friends. When his friend Sam got the new Nike Air Max shoes for his birthday, Thomas wanted exactly the same. When Henry's mum let him put gel in his hair, Tommy begged you to buy some for him. You tell Mrs. Smith that you've been looking at the statistics. 10 to 15 years ago, there were maybe 1 or 2 children a year reporting to gender clinics with signs of gender dysphoria. Today, gender clinics around the country get more than 200 children a year. In the last 4 years, there has been a 1,000% increase in the number of children on puberty blockers or hormone treatment. And you're just a little bit worried that telling Tommy and the other kids that they can change gender will confuse them. Mrs. Smith sympathises, but her hands are tied. Schools aren't allowed to discriminate against trans kids. And this means that if there is any type of bullying by other students, then they have to be disciplined, because for the school to not do anything is consenting to that discrimination. But Tommy isn't bullying, you say. He's just expressing what we have taught him to be true. But there's no law protecting Tommy or you in this situation, she explains. While statements of belief are protected under the Federal Religious Discrimination Act, it doesn't protect against harassment or vilification, and misgendering somebody or dead naming them is seen as both. What about Maggie? She's in year 8 and she's about to go on a 3-day school retreat. She informs you that Tanya, who used to be a boy named Tony but has transitioned, will be in her cabin. You ring the school and you tell them that you don't want your 14-year-old girl in a room with boys, but their hands are tied in a similar way. No discrimination. Maggie's not upset. She watches TV, gets the concept of trans kids, and she doesn't care. She likes Tanya and she doesn't understand why the Catholic Church hates her. You try your best to explain that it's not about hate, but it's about an understanding of the human person. But it's really hard to do that when the school's no longer allowed to back you up. You get the sense that somehow you are less free to raise your children in accordance with your beliefs than you were before the religious discrimination stuff was fixed. Yes, my story is hypothetical, but it will become a reality if we allow a religious discrimination bill to be a trade-off for the Australian Law Reform Commission inquiry. We must not stop engaging on religious freedom when and if the government passes this bill, because governments can give with one hand and take away with another. Or alternatively, governments can give with one hand and sit back while the states take rights away, not seeking to intervene out of respect for states' rights. One state law that is likely to pass without too much resistance is the ban on so-called conversion therapy, planned for at least Victoria and the ACT. I want to make it clear right up front that in talking about religious freedom aspects of conversion therapy, I'm not endorsing practices often associated with conversion therapy, such as electroshock therapy, giving people nausea-inducing drugs, or other forms of physical violence in the name of aimed at changing a person's sexual orientation from homosexual to heterosexual. These are practices that offend the dignity of the human person, and of course we reject any and all attacks on human dignity. But unfortunately, these therapies have become conflated with ideas of conversion and the promotion of chastity, but they're very different things. As Martin Iles from the Australian Christian Lobby has said, conversion therapy is a misnomer because churches are in the business of conversion, while health professionals are in the business of therapy. But governments don't make the distinction, with Victoria and the ACT looking to regulate not only medical practices, but pastoral and prayer activity as well. And it all depends on what you define as conversion therapies or conversion practices. The Victorian Health Complaints Commissioner has described conversion practices as any practice or treatment that seeks to change, suppress, or eliminate an individual's sexual orientation or gender identity, including efforts to eliminate sexual and/or romantic attractions or feeling towards individuals of the same gender, or efforts to change gender expressions. The key question, it seems, for us is, what do they mean by suppress, and who will be able to decide? Will it be defined in the legislation, or is it something we're going to leave to the courts? In the Victorian Government's issues paper for its public consultation on this issue,